for you. So if this is your first time, thank you for joining. If this is you joining us for our weekly webinars, thank you for continuing to participate. My name is Juan Deshawn. I'm one of the IRA specialists at Quest Trust Company. Today we have Jason Oxner with us. We're going to talk a little bit about the topic towards the end. I want to kind of reach out right now to the newer people that are just joining us. I'm going to go over kind of really briefly over what Quest Trust Company does. We want to make sure to continuously provide you guys with the best education possible. If you guys have any topics you guys want to hear about, please let us know. I also have my colleague Nicole Bako on the moderating chat box. So when you guys have questions, feel free to use the chat box to just chat with us in general. Use the Q&A box. I think we're going to wait for presentation questions till the end. But please make sure to use those resources to your best ability. Like, share on Facebook. The recording of this video will also be on Facebook once it concludes. So I'm going to very quickly over here share my screen and then share some slides to just briefly go over what we do here at Quest Trust and to make sure that you guys kind of just understand a little bit more. So Jason, if you don't mind confirming for me, you see my slides right now?
I can, yes.
Excellent, awesome. So, and you see it like full screen, right?
Yes.
I want to make sure. So again, thank you for joining us, guys. Very briefly, if you haven't met me, my name is Juan Deshawn, one of the specialists here. We're a Quest Trust company. We deal with self-directed IRAs, right? So we're dealing with IRAs that invest into non-traditional assets. And I mean, that's just a whole variety of things. And so if you guys have questions on how to use your IRA and not kind of jump into the stock market, we're the guys that you ask, right? Now, who we are not is we're not lawyers, CPAs, attorneys, financial advisors. We're here to educate you and let you know how to use IRAs, what to do and what you can and cannot do so you can make the best decision for yourself. Use professionals like Jason here to then go further and see what's the best plan. And he can give you that kind of advice as a lawyer and assist you in that sense. So we're just one tool in your tool belt. So keep that in mind that we're just not endorsing anybody. We're trying to provide you with just fantastic education. So very briefly, if you guys do not know what a self-directed IRA is, but maybe familiar with IRAs or 401ks, a brokerage firm or with your job, and you understand that it's a vehicle for your retirement, right? You are putting money in maybe a monthly basis, maybe a quarterly basis, but however you are, you're putting money in to eventually defer taxes and have some sort of nest egg for your retirement. Now, a self-directed IRA takes all of those components and then just changes it a little bit on what you use the funds for. Instead of using it in traditional sense like stocks, well, you can now use it for things like real estate or private businesses, right? Huge benefits are diversification, right? You're going from the stock market now to the private side. Tax savings, of course, as I mentioned, you can diversify your portfolio, or you can even have tax-free profits. Social investing, what that means is you can essentially invest in your own community and then invest in what you know best, right? If you are a real estate investor, if you have your own business and your niche is not necessarily the stock market, you can apply your knowledge towards your retirement and hopefully increase how your retirement account will grow. Now, you may be familiar with some of these plans. You may have some of these plans. Again, as I mentioned, they're exactly the same as any IRA plan you may have anywhere else. We have our personal, employer, and specialty plans. So most people may have a traditional, some people may have Roths, and you even might find some individuals that have SEPs and 401ks, right? Very few people have HSAs, health savings account, and covered out education savings account. All these accounts are ones that Quest holds, IRAs that you can use towards your benefit for the future, and some of these even for now. So again, we're the guys who ask us, how do I use these accounts? How can they better serve me? How can I attain one? And then you ask people like Jason to kind of put everything together. Now, investment choices, very common things we see here are real estate, private companies, and promissory notes. All right, so as you can see here, you can invest into all kinds of things. If someone told you before that you cannot invest your IRA into real estate, that is wrong, right? It's just you need a custodian to be able to facilitate that investment and hold the asset for you on your behalf and not cause any taxes. So as you can see here, you can invest into single family, joint ventures, LLCs. You can do some secured and unsecured loans. I personally am kind of in the secured loan side, right? I do secured loans in my Roth IRA. I have clients that are constantly buying single family homes, and I have a lot of clients who are always investing into LLCs or making joint venture partnerships, all right? So take a look at how you can maybe diversify your portfolio, your current IRA assets, and see how you can get involved by just letting us know. Now, on the other side of Quest, aside from our just education of IRAs and administering them, our big side is education, right? An educated client is the best thing that we can have here. And so if you guys want quick videos of how you can use this instead of having long webinars, check out our YouTube channel. There's Quest Trust Company on YouTube. Go to our education center on our website at questtrustcompany.com. You'll find some archived videos, some blogs, etc. And if you're an individual, maybe looking for deals, maybe even looking for private lenders inside of an IRA account, looking for people who have the IRA money to lend you, join our virtual network happy hour, right? Quest cannot endorse anybody or tell you where a good deal is, but we can bring you in the same room together and hopefully you guys can connect. And so this is, we do it twice a month, first and third Wednesday of the month at 6:30 p.m. on a Zoom call, completely free for everybody. I think it's fun. You know, you can have a drink in your hand, whatever you prefer. It goes about an hour or so. You have a Quest moderator. So please check it out, join, completely free. And then we also have, again, weekly webinars, right? Every Tuesday and Thursday at 12, we have the one on Saturdays. So there's always constant education. As I mentioned, they also get recorded and posted on our Facebook. So you can rewatch if you couldn't attend live. Like I said, Self-Direct Saturday as you are joining today. Now, what Quest has going on right now, and actually almost ending right now, is we have a Quest bundle going on. If you're an individual looking for more education, this is a very, very good opportunity for you. If you set up an account because you're going to use it for retirement and you have some plans to do so, well, then you can also, on top of that, get a free ticket to our QuestCon. Our QuestCon Live is essentially our Quest Expo, but online. Now with COVID, we had to basically assimilate to the system and now do everything online. But it's a huge trade show where you can take advantage of education, gurus in the market, gurus in the real estate sector on different topics, teaching you how you can kind of grow your own personal business. And so this is very, very helpful. You get a free ticket, you get the free recording, and you even get an ebook that kind of shows you case studies. So if you're like, hey, Juan, I don't know how to use my IRA, I'd like to see some examples. I personally am a visual learner. That case studies ebook is really useful. So if you guys open an account, please let an IRA specialist like myself know that you want to use QCL bundle, right? That is the coupon code. Now, the account does cost $100, but you do get a lot of value for it. How to get in touch with us? Again, Quest Trust has a live chat box. You can always speak to a specialist on the chat box. It's no robot. You know, it's actually someone on there at all times. I'm there about once, twice a week. And then you can actually chat with us from the hours of 8:30 a.m. to 5:30 p.m. Central. Give us a call, 855-FUN-IRAs, or email us, IRA specialists, that's plural, at questtrust.com. Right? But then again, follow us Facebook, YouTube, even Instagram and LinkedIn, right? And it to be very, very easy, if you guys take out your phone right now, you can press this QR code, and I'll show it later if you need to, but you can press this QR code, it'll take you to a place to schedule your free consultation to speak with any one of us. We have no reason to want to persuade you to join us if it's not the right thing. We don't make commission, nothing like that. We're here to help you and just simply educate you to help you make the best decision, as I mentioned. So please schedule a call with us. Again, I will be on here moderating as Jason takes on the presentation. Nicole Baker will be on here as well. So please ask us questions. We have a fantastic presentation for you guys coming up on essentially how to run your business from a lawyer's perspective. We get questions all the time on how should I do this? How should I do that? And again, I cannot give that kind of advice. So I point you in the direction of people like my friend Jason here. So please give me your undivided attention, send the questions in, and let us know. Jason, I'm gonna let you take away. And you're on mute right now, Jason. There you go.
Okay, there we go.
Yep.
Okay. Perfect. And let me do this.
Right now, we're looking at the slide where you see the first slide and the next slide. You might want to
sorry, I'm going to switch it over.
There you go.
There, is that better? Perfect. Okay. Let's thank you everyone for having me and coming here. But I believe to now be the afternoon on Saturday. I'm sure it's not what everyone wants to do on a Saturday is listen to a lawyer speak. I'm very passionate. I think is a fun subject, but I'll leave that up to you. So I'm Jason Oxner. I'm one of the partners at Oxner Legal Law Firm. And today I'm going to be speaking of the topic, running a business from a lawyer's perspective and experience. One of the fortunate things that I have is in representing a lot of businesses, I get to learn a lot from them as well, the good and the bad, what works, what doesn't. And then I get to inject my own legal opinion to those experiences as well. Legal disclaimer, not surprising as an attorney, I'm going to provide you with one, that the information provided is not intended to be as direct legal advice and should not be taken as legal advice. The content provided by the speaker within this presentation is meant as general information only. Each of your situations is unique and demands a careful analysis by a licensed and qualified attorney. I am not a tax attorney. I'm not a CPA. So a lot of these things, as Quest Trust has mentioned as well, involve taxes and other considerations, and I'm not the one to answer those. So about us, Oxner Lega, we have practiced in business law, family law, estate planning, probate, civil litigation, personal injury, insurance claims, and more. We're a boutique law firm in Cypress, Texas. There are 6 lawyers along with our amazing support staff. And a shameless plug, we are expanding. So if anyone knows of anyone looking to sublet some space along 290 for the next couple of years, we'd be really interested in speaking with them. Our lease is coming up, and we've also outgrown it. We grew it last year, but we had everyone move to work from home. A little bit about me. I'm not going to go through all this. I did law school here in Houston. I'm originally from Canada, and I got my master's of law at St. John's University in New York. So what am I going to be talking about today? What's the outline? So we're going to first discuss selecting the right business entity. So I'll go through the different types of entities. Then I'll move on to what governing documents every business needs. Then what business owners can do to avoid potential lawsuits. And at the end, I'll open it up for questions. So businesses are exciting, at least I think they are. They end up taking on a personality of their own. They have the potential to outlive their founders. I'm sure we can all think of companies that have been around for at least 100 years. None of the original people that were there to begin with and start are alive today. So businesses have the potential to live in perpetuity. I like to say that businesses are like people, but without the ability to sign their own name. Their businesses are people without arms and legs. So someone needs to sign on their behalf. And that's really what we try and focus on as lawyers, is separating the business from its owners, its shareholders, and really shielding that liability to create that entity away from the personal individual or people. So topic 1, selecting the right business entity. We'll first talk about the types of business entities. The 4 entities I'm going to be discussing with you this afternoon is 1, sole proprietorships, 2, general partnerships, 3, corporations, and then 4, limited liability companies. First, sole proprietorships. Sole proprietorships can only transfer business interests by selling the business assets. Access to capital can be limited. Potential for more tax liability. And no entity taxation, because no entity to tax. It's passed through taxation. It's the most common and simplest form. A single individual engages in business activity and formed without the need of registering with the Texas Secretary of State. Now, I realize that you can designate an entity as a sole proprietorship with the IRS, but in this situation, I'm discussing a DBA, or an assumed name, where someone hasn't formed anything with the Texas Secretary of State and nothing is recognized as an entity with the Texas Secretary of State. And as such, there's no limit to liability. So as I mentioned, if you have a DBA or an assumed name certificate, and that's not attached to an entity, it means that the individual is not protected from liability. Limited liability means just that the liability is limited to the entity. So DBAs are not entities that afford limited liabilities. I will sometimes have clients come in and tell me they have a business. I'll ask if they're formed, and they'll say, yes, I have a DBA. And that's when the conversation changes completely, because now I know that what we're about to discuss, especially if it's a defense matter, something they've been sued on, that they may be open personally, that everything they own may be subject to garnishment or this lawsuit. Moving on to general partnerships. This is where two or more persons or entities associate to carry on business for profit. For profit is the underlying factor there. Business done according to a partnership agreement, which can be oral or written. There are no formal organization requirements. And again, I'm discussing as if this is not a formed entity with the Texas Secretary of State. Any partner can bind the business, meaning they have agency authority to bind the two partners or more than two partners. And in this, they have pass-through taxation because there isn't an entity being taxed. I also caution my clients, especially contractors, those that are doing buildings, that actually two LLCs, if they are formed LLCs, can form a partnership as well. Because as I mentioned earlier, entities can form partnerships. And as such, you could have another LLC binding your LLC if there's a partnership. If the two entities are carrying on and conveying to people that they are a partnership, that they're doing this project together, and it hasn't been communicated to the other parties, the third parties, generally the client, that they're providing construction services for, contractor services for, that they aren't independent, that they are doing essentially a joint venture as a partnership. Moving on to corporations, one I'm sure you're all very familiar with, was up until recently the preferred method of forming an entity. Corporations in Texas are created by filing the Certificate of Formation with the Texas Secretary of State. It features limited liability, centralized management, as I discussed before, endless duration, simple transfer of ownership, the owners equal shareholders, and the management is vested in the board of directors. It's an independent legal entity, as I mentioned earlier, that it exists on its own and possibly in perpetuity. Taxation, corporations, and one of the reasons why people have moved away from them is the double taxation. The entity, the corporation, is taxed, and then the shares are taxed. But with corporations, and why they are appealing, is that shares can be easily transferred to any person or entity. I'll highlight again, shares can be easily transferred to any person or entity. This is, I'll bring this up, because why? Maybe you guys have heard of these people and what's been going on recently. Easy transfer of shares, or it was supposed to be. And I won't comment on all of that, but one example of shares being passed around. S corporations, so the Texas Secretary of State does not recognize S corporations as a state corporate law structure. It's a federal tax election under the IRS chapter S, or sorry, as designation S corporation. Taxation, unlike a C corporation, which we just discussed, is passed on to the shareholders, or what we call pass-through taxation. Under the IRS, there can only be one type of class of shareholders. Shareholders must be United States citizens or residents, and it cannot exceed 100 shareholders. And with it, like other entities, it affords limited liability. Corporations, it is a rigorous management and governance structure, so there are some complexities there. Again, they're not for everyone, and for others, it is the right move to form a corporation. You need a registered agent for service of process, where if the entity is to be sued or receive legal service, that someone be able to accept service on behalf of the corporation. The agent can be an entity, but it can't be the entity itself if the registered agent is listing itself. So you can use another entity that isn't the corporation that's being sued. need at least one director, and need at least president and secretary as officers. You need to have annual meetings of directors and shareholders, and directors and officers elected at annual meetings upon the expiration of terms. Moving on to limited liability companies. As my business law professor stated on the first day that we just started discussing LLCs, the LLC is the wave of the future. He's very excited. Got very animated from being a dry, knowledgeable man, but he loves the LLC, and I think that's what picked me up and why I've been so fascinated with them since that day. So about limited liability companies, again, they're very popular. We're forming one every 4 days. I just checked this the other day. We're forming them all the time for people. We see this particularly where we have a downturn. A lot of entrepreneurs pop up, people lose their jobs. They look then to form their own company. So what are we talking about with limited liability companies? So they're created by filing a certificate of formation with the Texas Secretary of State, as was with corporations. Has the powers of both a partnership and a corporation. It's a good mixture. Combines management of general partnership, but affords the limited liability protection. And it has the benefit like an S corporation with pass-through taxation. The governance is through its managers or members, and I'll get into that in a little bit. And it brings the benefits of all the entity structures basically into one. The LLC is a more modern entity. And the owners are in Texas are considered members, or we call the owners members for an LLC. As I mentioned, the LLC can be either run by the members, what we'd call member managed, or manager managed. So for member managed, the company is run and governed by the members, by the owners. The members, unless it's stated otherwise in the company agreement, or what others call shareholder agreement or operating agreement, they essentially run the company. The owners run the company. Versus manager managed, where we have members, but they might not be playing an active role in running the company. A manager is elected or hired to run the company on behalf of the members. And we generally, if we have a company that we're setting up or we need to transition, we would like to use manager managed to further protect the liability on the back end in bankruptcy if that were to get all that far. Not something any of us want to think about, but people come to us to plan for the worst. We hope for the best, but plan for the worst. So we do a lot of manager managed companies. And again, that's where the members may not have a direct role in running the company. They're hiring or electing someone for the management of the company. And there are different creative ways to do that as well. As a quick side note, there are also professional limited liability companies, and which really just means that some companies must be designated as a professional limited liability company. So for instance, as a law firm now, if you were to form an LLC as a law firm, it would have to be a professional limited liability company. And it's just a simple designation with the Secretary of State. It doesn't change all too much, except there's a P in front of the LLC. And the Texas Secretary of State has a great guide for determining which entities need which designations, and also which entities or types of businesses, I should say, can form an LLC or different types of entities on there. And I haven't covered all of the entities, but on there's a good guide on what type of business you're planning on running and what options you have to select. So what company do I pick? And everything is unique and specific to the company. And sometimes those things change as they grow or shrink or transfer into something else. But as we've begun with the DBAs, the sole proprietorships, the partnerships where we don't have any formation, For us, in that first column as lawyers, that's the biggest thing we're looking for, is the limited liability. The LLC, the corporation, the S corporation, those all have limited liability. Then we're looking for simple governance, which the DBA and the sole proprietorship do have, but the LLC also has. The corporations don't. Doesn't mean it's a reason not to go with the corporation, but there are just more things to consider. Then a big thing for a lot of people, of course, is the taxation, whether or not there's pass-through taxation. And then for some of our clients, the startup capital, the cost to get these done. Is it easily formed? Can it be done cheaply so they can put their money into other areas? And that's what the LLC affords. So really, if you're starting out with a smaller business and looking to grow, not going to have too many partners or shareholders, then it's most likely that the LLC is the way to go. And I'm sure, though, many of you probably already know that, really, that you've heard of the LLC, you're aware of why people form an LLC. If you don't have any of the bottom three entities, or if you've not formed an actual entity, and you have rental properties, you have a business, I highly, highly, highly suggest that you form some type of entity, most likely an LLC, because you want that personal protection. You don't want to have everything you've earned and made and transferred to your personal account be subject to a lawsuit if that business that you're running does get sued and you don't have a business structure, an entity, an LLC, a corporation, S corporation formed. But again, as I've mentioned several times, choosing an entity is not a one size fits all. There are different reasons to choose different types of entities. So not everyone that comes through my door do we suggest an LLC or do we suggest an S corporation. It also depends on what's going on with the tax code. We pick up the phone a lot of times and like to speak with our clients, accountants, and financial planners and get their thoughts on it as well. So topic 2, governing documents. You really want to establish governing documents. Sometimes it's mandated. The beginning is the certificate of formation, how you're forming the company, what is being filed. Then, as I mentioned earlier, the company agreement, or what others call an operating agreement for an LLC, or bylaws. In these things, you're going to want to list the ownership percentages, how you're going to be sharing profit and losses, the management and the company roles and voting rights, along with member withdrawal, what happens if one of the members wants to leave, what happens when you want to dissolve the company, and if there's a method of valuing the company. And I tell my clients, especially when we have 2 or more business partners that are coming in and wanting to form a company, I always tell them, now is the time to get all this done. I know it's expensive, but this is the exciting time. This is the time where you're looking forward to the future and everyone wants to get this thing rolling. So this is the time to put all that in writing, because it's often too late, especially when you come to us, when something's not working out. And then I ask, well, what do you have in writing? What's your company agreement, your operating agreement, your bylaws, shareholder agreements? What do they all say? And if they say nothing, then we're defaulting to the Texas Business Code, and it's not good. Texas has a very hands-off approach for the most part to businesses, following the business judgment rule. So at that time, it's difficult to get out, and it can be very, very costly, versus when you're forming these things, when things are going well, everyone's getting along. That's the time to discuss these things. That's the time to put these things in writing. And then also you can learn a lot about your future business partner at that time in these discussions. Buy-sell agreements, another thing to include, basically what happens, the exit strategy, conflict among co-owners, morality clause, what happens if one of your co-owners just does something in the public media that really tarnishes the name of the business that comes back to the business. You actually see a lot of the morality clauses in sponsorship deals with athletes, including a voluntary cash out clause, Another big thing to consider is what happens on a member's death, an owner's death. Another big one is divorce. I don't practice family law. My law partner does in her department, but I often get brought in if one of the spouses has a business, because there might be a clause triggered in the governing documents of the business as to what happens to that business if one of the partners becomes divorced or is going through divorce. Because in Texas, as a community property state, even though a spouse's name might not be on any of the governing documents, the formation documents, but if it was formed during marriage, there's a good chance that that spouse may have a claim to a portion of his or her spouse's share of that company. So we don't want them to have a seat at the table, especially after a divorce. So there might be triggering clauses in there that the business will buy out those shares, or the spouse that is getting divorced, the owner of that share or that member may have to buy out their spouse prior to the divorce or account for in the divorce decree. If not, then the members have the opportunity to then buy out that partner, that other member's share, which would include the spouse, so that we can keep the integrity of this business and its ownership structure. Okay, so these are all great, right? And probably the reason why you're coming to me today, why you're coming here today, is, well, how do we protect ourselves from being sued, right? Well, if I told you guys that, then how am I going to make any money? Lawyers make a lot of money off of lawsuits. That's no secret. But I will let you in on some of the things that we do, the things that we recommend. Again, a lot of them were just discussed very briefly, and I ran over them with the governing documents, because a lot of the times we see it's internal fighting that can shut down a business. I'm sure you hear about these things in the media as well. So if you have those and protect the home base of the company and exit strategies and different things, that can really make you a solid company and avoid internal lawsuits, which can just cripple the company. Or you can have a lame member staying on with no way of getting rid of them. You can just tank the company. I see it so often, especially in times like this where business can be difficult for people practicing in an economy like we have one today. So again, form an entity with an attorney. Whether you use us or some other law firm, I would just say, do not go online. Do not form it online through a third-party online company. Do not use their governing documents. If you do, then take them to an attorney, take them to a business attorney that can help you go through them and understand them, and also what should be removed, what should be added before they're signed. Or if you've done that, you just formed your company and you have a business partner, or if it's just you, take them to an attorney as well. Take them to an attorney now. It's before things get bad, right? You want to know what are in those documents. You want to understand what are in those documents, because if anything happens, those are the documents that the lawyers are going to pull out and need to use and reference to see what needs to be done, what rights are available. And then with entity naming, must be distinguishable from other names with the Texas Secretary of State. So don't use a business name, a very simple thing. That's the same as another one. Secretary of State generally looks at the first two words of the business name. Designate a registered agent and keep that address up to date. I mentioned earlier about registered agents. Every entity needs to have a registered agent. It cannot be the name of that entity. It can be a person of that entity, but it cannot be the name of the entity. You can use another entity, as I mentioned. So a registered agent does not assume the liabilities, debts, or obligation of the entity, of the business, and you cannot list an address that is a P.O. box. We serve as registered agents for almost all of our companies, with some exceptions. But my clients like to say that if they're being sued, they'd rather their attorney know it before they do, So I can break the news to them and explain what it is versus them getting the papers maybe over the weekend and having to sweat it out and have no idea what's going on until they're able to get hold of me. The registered agent doesn't mean that's your business address. It's just, again, where someone can serve the entity through the registered agent. And if you have a registered agent, or if you're designating yourself as a registered agent, make sure you're checking on that regularly, that if you've moved or something, to update it. Consulted with a client last week. They hadn't updated their registered agent in a number of years, and they had a big lawsuit outstanding against them. They weren't serving them. I don't know why they weren't served, but I know it was also because the registered agent wasn't up to date. So the lawsuit had progressed pretty far, and that's because my clients didn't know about it until recently, after it had progressed for a few months. So keep your registered agent up to date, or again, use an entity, use our firm, use another firm, so that you don't have to worry about it, that they'll keep it up to date for you. Another thing is, do not think that you're just simply done when you've filed or created your entity. As I mentioned before, you need to adjust your documents, you need to adjust things and reevaluate your business as it changes and transitions over time. It's something to revisit and look at, manage. And another thing, when you're just filing and creating an entity, as I've mentioned, it's not going to help you with member disputes, governance, and full asset protection. There are things to consider, and I'm not saying this to scare everyone and to run out and get an attorney and spend money on it, but it's just something to keep in mind, and it will really, in the end, save money if you go ahead and consult with an attorney to understand everything that you have, and just something you can't get online when you're getting these things through a third-party online company. Another big thing, or I should say a mistake I see a lot of clients make, is they have an LLC, they formed an LLC, but they haven't moved the assets of their company into the LLC. I see this a lot with my clients that have rental properties, and sometimes they can't move them in if there's a mortgage or different things, but you need to eventually move them into the LLC. Otherwise, you're not protected. If things are in your personal name, you're not protected. It needs to be under the LLC. The LLC needs to own the property, the assets. Another thing is if you have a property that it's your home and you've homesteaded, I've also seen people move those into an LLC thinking they'll get greater protections. The reason why you homestead your home, the one that you're living in, is to be afforded protections from lawsuits. Now, you can only, of course, homestead one of your homes. So if you have rental properties, income properties, those you're certainly going to want to move into a type of structure, whether it be a trust or a business entity, as recognized by the Texas Secretary of State. Another big thing, especially when companies are going down, that I see that's very sad, do not just sign your name on behalf of the company. As I mentioned at the very beginning, companies don't have arms and legs to sign on its behalf, but someone else needs to do that for them. So when you're doing so, indicate that you're signing on behalf of your companies. For instance, of myself, Jason Oxner, partner of the Oxner Legal Law Firm. I'm indicating who I'm signing on behalf of, the Oxner Legal Law Firm, and what designation. I'm a partner at the Oxner Legal Law Firm, and then who is doing that? Me, Jason Oxner. Another big thing I see happen, which can get my clients into a lot of trouble, is when they commingle funds. When they use the business credit card for personal expenditures and vice versa. Now, that doesn't mean, sometimes you forget one of the cards at home or you mix up bank accounts. It's okay, right? You can just transfer it over or account for that in some way, be reimbursed, make sure it's on paper and track it. But another case we had, a sad case, was a father, his twin boys turned 16, business was going really, really well, and he went out and bought them each $80,000 trucks. It's fine, spend the money you want, but the problem what he did here was he used the company card to do so. his boys, neither of them were employees of the company. And now we need to justify why this business owner is using the company card to buy $160,000 worth of personal assets. He's commingled the funds. He's mixed business with his personal account. So if he had just that day, rather than swiping the business card, had transferred money over from his business to his personal account, saying, oh, I need a bonus today, and then used the personal account to buy those trucks, we wouldn't have been in that problem that we found him in on that day when he came to us. Another big thing, a simple thing, but I think it's very often overlooked, is keep meeting notes. Some entities are required to have annual meetings and occasionally even more meetings than that, depending on the document setup and the entity creation. But keep meeting notes. Have a secretary as designated by the company who's taking the notes, and have formal meetings. It's good to circle back, and it looks good for us, for our clients, if they're sued, that we can say they've had meetings, to say they're a real business, that they're conducting the business as it should be. Another big thing that I just mentioned, right? Get a separate bank account for the business. Do not put everything in your personal account. That's just a recipe for disaster. So to kind of help everyone, I'd like to discuss a recent case study that we did. And in fact, this is becoming pretty popular. So what we're discussing, while it's one client, it's been something we've been doing a lot lately. So let's start using some nice graphics, get away from that boring text. So I have a husband and wife. They come into my office. They're an older couple. The husband, he has adult children, and the wife has adult children. So they came into this marriage with, it's their second marriage each. And in fact, they have a lot of children. So combined, they have, the husband, I believe, had 4 adult children. The wife had 5, and combined, they had 23 grandchildren. So it's what we call a blended family, children that weren't born of the marriage. And so the wife, she had a rental property. In fact, she had 5 rental properties. And then the husband, he had a rental property. He had 5. They actually met at something quite similar to this back when things were done in person. Both, one was widowed and one was divorced. And they had met as property investors, real estate investors, income properties. So if we looked at the wife's portfolio, what she had, and I've changed the names of the addresses here, but if you can imagine each one being the street address of the property here, she was good, better than a lot of other people we see, in that she had each each property in a separate LLC. This is a great structure for asset protection, because if this property is to be sued, the top one, 346 Oxner Street, well, that's the only asset that can be seized if a lawsuit were to go ahead on that property. So the other properties could not be subjected to any lawsuit because they're all in separate entities. However, we'll get to that in a bit. Then we had the husband. He had 5 properties as well. The top 2 properties were in his own name. They're income properties. That's really bad. No LLC. Then the bottom 3 properties he did have in an LLC. So that was a bit better. But moving on. And then they had one property together that they bought after the marriage, and they put it in both their names and their personal names because they just didn't know how to structure it. So what did it look like when we listed it all out? So the wife had 5 properties, each in a separate LLC. Then they had one shared property and in both their names. And then we had the husband with 2 properties in his personal name, and then 3 in an LLC. So like every good story, there needs to be a villain. The bad lawyer, okay? So back to our happy couple and all their children and grandchildren. And then let's insert the villain into our story, okay? Now, if they didn't have any entities set up, if they're all in their personal names, or in the husband's case, where he had 3 properties under one LLC, and this actually just happened in California within the last year. In California, what happened, this gentleman had 3 properties in an LLC, had $1 million of liability on each of the properties. However, he was sued and lost on a judgment for $5 million. So all 3 of those properties, his main source of income, his entire assets were all seized. All 3 of those properties were taken because the insurance it accumulated into $3 million, and the judgment exceeded that. So it was a $5 million judgment. He lost all 3 properties, and just not something he would have thought would ever happen. He thought he was doing the right thing. He put them in an LLC. The other issue with our wife is that she has them all in 5 separate LLCs. So for her, if this had happened to her, she would have been protected, right? They could only go after one of the properties because it's under an LLC. Each LLC is different and distinct, so they could not have gone after the other one. She would have been good, but the problem is here, and this is where I say I'm not a tax attorney, I'm not an accountant, but each one of those entities is likely to have to file a separate tax filing. So the tax implications on this are difficult. And also you're then having 5 separate LLCs to manage, to account for, to keep up track of. So what happens again if we put our attorney or villain into the situation and they don't have anything formed, but they're all open? Well, he takes everything, right? Even if it's in an entity, if it's in just one LLC and it's not done properly, or it's not in an LLC at all, where we had for them, if one of their properties was sued where they had a property together that wasn't in an LLC, and then our husband who had 2 properties in his personal name and not an LLC, well, they're all open up. Wherever the assets are in this business structure as they came into our office, they're all open, okay? So our clients wouldn't be very happy if they were to be sued and they're to lose some assets. And what's happening here is they would have been sued, say, on one property, but the other properties may be subject to garnishment or to satisfy that judgment. So what did we do? So maybe you remembered from the very beginning of my talk, I mentioned what entities are we going to cover. And if you look to the bottom, the series limited liability company. And while I didn't mention it then, I had on that slide, it's going to be your new favorite, okay? Especially if you have income properties and rental properties. And again, before I get into this, I mentioned there are tax implications, right? So one of the reasons why we're doing these for our clients are the limited liability, and also it helps tax-wise. But whenever we're doing this, as I mentioned before, I just pick up the phone and call their accountant to make sure this all works out, and that while I may be protecting all their assets from lawsuits, I might be creating a nightmare for them tax-wise or further tax implications. So the series limited liability company, what I've termed to be your new favorite type of structure. It allows the owner to hold assets and liabilities within separate compartments, or what we call series. So each series operates as a sub-company under the LLC. So we're able to segregate assets and insulate them and the liabilities against them from other assets within the company. So we structure it so we don't have to worry about other assets potentially affecting another asset within that company. So they're each shield. There's a bubble around each of them. So back to our happy couple, what did we do? And mind you, they also came into our office for estate planning, which we do. And this structure also helped us a lot with estate planning, which I won't likely have time to get into today. But this structure the Series LLC is also very good for estate planning when you have a blended family. So we moved everything into a Series LLC, and we created a rental Series LLC. So one LLC, just one company, had all of these rental properties in here. And we transferred all of the properties into the name of the rental series. So it would have been 346 Oxner Street, a Series Limited Liability Company of Rental Series LLC. You have to name each one differently and designate that it is a series of a Series LLC. It's a mouthful the way you name them, and you have to name them with an assumed name certificate. It's more complicated to form. It takes a fair amount more work to do, but the cost savings, from what I've been told, from tax planning is enormous. And then also from a limited liability protection standpoint is huge. So if this 346 Oxner Street were to be sued, all the other properties were isolated and protected from that. But we have the benefit of having all the properties under one LLC. So it's all in one place, one tax filing, and we don't have to worry about the assets again being subjected to a judgment. So not every state allows a Series LLC, and much like why you can see here, because really it's just one LLC, but you're able to isolate and segregate each property within that LLC separately. So it's just a great, great structure. And after it's formed, it doesn't take much to maintain. The work really at the beginning, especially if clients come to us like they did, is forming the company. We formed a new company on this to start clean, filing assumed name certificates for each of the properties, and then listing them under the LLC in the company agreement. We had to also include with the certificate of formation all of these properties. And then we needed to deed the properties over to the LLC. So from each of their personal LLCs and then also in their personal names, we then listed the rental series as the owner, and more specifically under the assumed name certificate. Forgive me, I know this is all very technical, trying to get through it for you guys, but if you have rental properties, more than one, some will say if you have 4 or 5, that this is where you can have cost savings and you can protect all of those assets. And while it does take a fair amount to get started, it's not overly complicated. It's just more than just a simple LLC filing or creation. What's good for this one on the back end, it's actually really easy to add properties once you have it set up, or sell properties from it. It's incredibly easy. Versus in our wife's scenario here, she, when she came to us, had formed 5 LLCs. Again, forming an LLC in the beginning is not terribly difficult, but when you think of doing this over time, and there's continuing to add properties, we've added more since then, that forming just another LLC, another set of paperwork, another registered agent, another tax filing and such. So now it's just so much simpler for them. They wish they had done it a long time ago. And then specifically in theirs, this gets into more tax planning and then entity protection. And this isn't for everyone, but they also manage their properties. So we had another management company, LLC, set up so that there's one company that was managing the properties, and then there was one company, the rental series LLC, that was holding all the properties. And then we had a parent LLC on top of that. And then briefly for the estate planning, which was what was great about the rental series LLC, and because we had a blended family, is we were still able to account for who owned each property. Really what it was is almost looked like a prenuptial agreement, or what we call in Texas a premarital agreement, where the properties were going to really stay in their names, the husband and wives individually, except for that one shared property and the properties they're acquiring in the future together, so that they can leave it to their children separately. And so it's not all blended together. And from that, we included in the company agreement what would happen if one of them were to pass away and who each property would go to, or really who would slide up underneath that the husband or wife to then assume ownership. One other thing I see a lot when someone does pass away, when they have rental properties though, and in this situation, we had experienced adult children, but the people that may be inheriting these rental properties may have never really been in the business. They've not helped mom or dad, or it might be an uncle or an aunt, right? So I'd recommend, if you have rental properties, think about what would happen if you were to pass away, and who's going to manage those properties, because you don't want them to just be left open and everything you've worked towards be gone kind of overnight, simply due to, sadly, mismanagement, who you've left these properties. So if you can make and form a relationship either with someone else that does these, that you can list to kind of manage these properties until your beneficiaries are brought up to speed, or a management company that you're using to structure with them to continue on if you're to pass away, or to manage it for a certain time, or you're maybe designating that a management company will only manage these properties while your children or someone else may be the owners, right? You want to think, again, like what I started off with today, is businesses can live forever. They have their own personality, and you need to plan for that if that's what you want to do. And so you want to make sure that it's going to be continue to be managed properly if you were to pass away. So what would happen if we had our attorney here with all these properties, right? And if we had the series LLC and the worst case scenario occurred, if these were all under a series LLC, you could only take one of them. Yeah, it wouldn't be great, right? But they still have all the other properties. So in here, right, in our series LLC, he could just take one property. Even if he were trying to sue everything, again, only be able to take one property. Still not great, right? They're still losing one of the properties, but it's just one property versus the rest of them. If that judgment were to exceed the insurance or exceed the real assets of the entity. So it protects it, it isolates, and it segregates. It's just a great, simple business structure. Bit difficult to form, but not overly complex and easily managed on the back end. So again, this is what we had set up here. And then, if I may, on a switching gears on a very, very brief detour, because I've mentioned it several times and I see it all the time, sadly, when we do have divorces where I'm consulting on them from a business law perspective, is anything brought into the marriage can be separate property, but assets acquired during the marriage are presumed to be community property. Salaries in marriage are community property. So the reason I bring this up are Jensen claims. A Jensen is a lawsuit. So what I see happen all the time with divorces is when the spouses know it's coming and one of the spouses has a business and maybe that's their main source of income, they'll start underpaying themselves. And they think that's very smart, that they're like, well, I'm only getting this amount of money, and you can only garnish this amount of my wages for child support, or the value of the company is this, and they just start hiding money away. Well, a Jensen claim is a claim by the other spouse saying, you intentionally kept money within the company and you underpaid yourself. So the community estate, the marriage, is actually owed reimbursement for you underpaying yourself. So a lot of people try and do it. They think they're clever. They think they're the first ones doing it. They think they'll be protected because it's an LLC. But if you're an employee of that company, of your own company, and you're intentionally underpaying yourself, well, then we can do an analysis to say you should have been paying this, and therefore the salary that it's been based on, there's a reimbursement claim, that difference, and it can just get really messy. And so you just need to be aware of that. If you're thinking of using your business in your divorce in some way to hide things, it rarely works out, especially if we're brought on board. So I think I went a minute over, forgive me, but now I'll open it up to questions.
That was great. That was a lot of information. We have a ton of questions as well. After this list together here. So let's just run through the Q&A box, and if you want to read them out to you, choose a few, and then choose in the chat box. Is that cool? All right, Jason? Can you hear me?
Sorry, broke out. Are you talking to me, or someone else can read a question?
Yeah, for you. I was going to read the questions out. That's cool. I'll just choose a few from the Q&A box. Is that fine?
Perfect.
All right, sweet. All right, let's just go to this one was set in right in before we even started. So we'll see how this one goes. What precautions should out-of-state business owners take to mitigate litigation with real estate investments? I think you kind of answered that a little bit in the presentation, but go ahead.
Yeah, certainly. So this actually comes up a lot with my clients, and the big thing is you have contractual liability, and then you may have property liability. And by that I mean it's extremely rare that whatever state you have that property in, that you're not going to follow that state's laws. So while you may be a Texas LLC, if you have property in Ohio, it's more likely than not that the laws will be followed of Ohio because the property is there in Ohio. There are a lot more other things that can be discussed, but if you're operating in another state, it's more likely than not you're going to have to register that foreign entity, as we call it, with that state. So definitely speaking with an attorney in that state, and not just the state that you may be operating in, but where you have that property held.
Do generally the rules from state to state vary significantly? Someone asked that in the question, and it kind of well adjustment.
Yes, they can. And it's just because there's so many things to take into account. The homesteading, whether that's done marital property, community property versus separate property, exemptions and such. So yeah, they do. Whenever I have a property in another state, I have a short list of attorneys in those states that I trust, and I reach out to them and kind of exchange the different things with the client on the line, so they can learn what the differences are and what we need to do and look out for in that other state.
Yeah. And you talked a lot about obviously active real estate investing, but would you recommend maybe a different strategy for more passive investments? For example, we have some people that do, and there was a question here, they do promissory notes, mortgage notes, and would a series LLC also help them in that?
Yeah, it really depends on how what you're doing. I mean, sometimes it's passive if you have a manager manage LLC where the owner is not managing it, so they're stepping away. Everything's just left in the LLC. It's good, where you have really good protection there, and it's isolated. So, and then other times with investors, actually, we'll have them use. Someone will come to them, and we'll ask that whoever's coming to them for investment properties, that they have a series LLC, so that our investors can be inserted into one of those series. So it makes it a bit tighter and cleaner, and protects our investors from that company, to make sure that their assets, just like I've been going over, are protected as well, so that our investors who are looking to eventually receive passive income aren't going to be subject to everything else that's going on with that company.
And got to throw a little bit IRA question in here, but how would you recommend setting up manager managed IRA LLC the technical control LLC for optimal estate planning purposes. So using an IRA essentially as a member of the LLCs, is there a certain way that you usually see that happen, or on the operating agreement and all that? Is there a certain specific?
Yeah, I really don't know how to answer that one right now. Though that if someone asked that, that's when, because it's generally that it's a tax planning issue or legacy planning or whatever it may be. So that's when I'm letting usually the accountant or someone else take the lead on that. And really, I'm on the back end to find out and make sure we check all the boxes and form it properly.
Right. If an IRA is involved, it's okay if the IRA is kind of a member of the LLC, but a passive member, and someone else is kind of taking the reign there, managing and all that. Do you see that often? Or do you see that at all?
I don't see it too often, but it also depends. We want to see who else is going to be on the documents and the paperwork. Sometimes we like to have, especially in a more litigious type of company, that it be manager managed and that we're isolating that owner or something. But you also have to watch out for who else is on the documentation with you as well.
Excellent. 1 second, Rodney. There's a whole lot of questions here. Let's see if we can get that one here. Okay, Rodney. He's asking, what protection do assets within a self-directed IRA have? Will there be greater protection if each asset are owned by a separate self-directed IRA?
I'm just going to turn up my volume here a little bit so I can hear the questions a bit better.
Sorry.
No, not your fault at all. So sorry, do you mind repeating that?
Yeah. So what protection do assets within a self-directed IRA have? Would there be greater protection if each asset is owned by a separate self-directed IRA?
You would look from the outside, and I need to look at everything, but you look at what is being sued and what structures that have in place, what limited liability does that asset have and is protected, and then who is controlling that asset. So it all depends on the structure makeup.
Can one of the sub-entities in the series LLC be used for wholesaling multiple properties?
You could, but that would kind of defeat the purpose. The whole purpose of the series LLC is to isolate each property, because that property, from the lawyer's perspective, is a liability. So we want to isolate as many things as possible.
My LLC is formed in Nevada, registered in Texas as a foreign agent. I'm considering moving the LLC to Texas. What would be the consequences?
Starting off the top, the lingering liability that may be existing there, some tax implications. Sometimes with that, we may want to form a new entity and then transfer the assets over. It just depends on why we're trying to do it and what assets the entity has. Forgive me, it's difficult to answer just because every situation is so unique, and Nevada might have better protections than Texas. So it depends where we can. If it's a fixed asset property, then we're subjected to that state's laws. Otherwise, we might form shop, as we call it, and put the company into a different state and the assets into a different state.
Yeah, I mean, a lot of these questions are kind of like, same way how IRAs work. Every situation is completely different. But here's one about the series LLC. Can you have a series LLC within or / under a C corp?
Yes, actually, we've done that. And then with the husband and wife example that we did, was owned by an LLC, a 2-partner LLC, and then it had an S corp as well in there. So you can do a fair amount with them, because entities can own shares. So
yeah, and I wanted 2 more questions. I want to respect your time. Saturday. Mira, hey Mira. She's asking, do you need an LLC for wholesaling, not taking ownership of the property situation? So I guess do you need an LLC for wholesaling? Is it recommended?
Not really, but again, we want to shield that person, right? If they're selling the property, they may be, or selling if there's a bad title claim or something like that. Again, we want to shield the individual from the liability, and that's really our job, is liability protection.
Gotcha. And here's a good one. If we already have only a couple of separate LLCs for rentals, is there a number of rental properties that you would advise, if reached, would benefit the series, where the series would come, into play?
Yeah, for us, it's like after 3, it generally makes sense, right, to put them into a series LLC. One thing I didn't mention, but really your best protection in all of these is insurance, right? Having a really good insurance policy. But yeah, after 3, that's where you see the management and the cost savings come into play, and to structure into a series LLC. So if you have 3 and you think you're going to expand, it's time to start putting some of that money in transition to a series LLC, because it will make it so much easier.
Gotcha. I'll just squeeze in one last one from David here. If the location of the property is in a different state, does the LLC have to be in that other state?
We highly recommend it. It doesn't have to be, but we highly recommend it.
Awesome. Well, Jason, questions are gonna. I think we got most of the questions. I want to respect your time. I know we had till 1, so thank you for your time, and thank you for everybody. How do we get? Who should we contact? How do we get in contact with you?
They can certainly give us a call at 346-327-9500, or visit us online at oxnerlega.com, or you can email me at Jason and I'll type it in here.
I don't know if did I write that right? 346-327.
Yeah, perfect. So yeah, you can reach out. Love to answer questions. Love to meet with anyone. And there's a website there.
Gotcha. Awesome. And guys, remember that if you guys want to review the PowerPoint again, see his slides kind of at your own pace, it's going to be on Facebook. We stream this live on Facebook as well. And once this ends, it'll be saved there on Quest Trust Company Facebook. So just take a look at it, share it, talk to Jason and his team at Oxner. And we'll hope to see you guys soon. Enjoy all Saturday, and thank you for joining.
Thanks for having me. Thank you, everyone.